In a quiet courtroom, tension builds the moment the hearing begins. Jonathan Schuster stands before the judge, declaring himself a sovereign and not subject to the court's authority. His words come rapid and confident, legal jargon mixed with defiance. He refuses his appointed attorney, insisting he represents himself sui juris, or in his own right. The courtroom remains still, the judge watching calmly as Schuster challenges the very foundation of the case.
Jonathan Schuster?
For the record, Abigail, this man was never appointed to me on my behalf. Like I told him the very first time I've ever met him, I'm here sui juris in propria persona. I reserve all rights. I, Jonathan Troy Colin Schuster, comma beneficiary and sovereign, and here under fraud, menace, and duress. Fiduciary, Abigail. This is a Social Security Cestacate Trust action, which you are now a real party and interest to. I'm here sui juris in propria persona. I've challenged the jurisdiction of this court, and I don't understand. So I do need some questions answered. Is there a bond on this matter?
I believe you were PR. Actually, bail was set at $2,000.
There is a bond on this matter, correct?
Yes, there is.
Okay, and so is
The judge explains that Schuster's bail is set at $2,000, but he interrupts, demanding to know if his Social Security number is attached to the charges. When told that it's part of his driving record, Schuster seizes on the detail, claiming it proves this is a commercial court and that a financial trust is being exploited in his name. His words echo through the room, turning a simple hearing into a confrontation over sovereignty and law.
my Social Security number attached to these charges in any way?
I don't believe so.
You don't believe so?
I don't have any record of your Social Security number. So as far as I know, I don't know your Social Security number.
No, I'm saying is my Social Security number attached to these charges in any way?
Only in the extent that it's connected to your driving history.
So is that a yes or a no?
In some way, shape, or form, your Social Security number is in the system with records on you. That is true.
Okay, so you just told me there was a bond, which means this is a commercial court.
It's not commercial.
Now you're saying that my Social Security number is attached to these charges. And so, which means this is a Cestacate Trust action, which you are a real party and interest to. And I just told you I was the beneficiary. You're supposed to be charged.
As Schuster continues, his statements grow more intense. He accuses the court of fraud, alleging they are charging the trust without his consent. The judge reminds him firmly, this court has jurisdiction. Schuster refuses to accept it, demanding the entire case be dismissed with prejudice. His confidence borders on disbelief. He sees himself not as a defendant, but as the beneficiary of a trust under siege.
Charging the trust, you're not charging the beneficiary. And if you're creating bonds against my trust without my permission, I don't understand. Are you saying you're committing fraud trust?
I'm saying that you are subject to the jurisdiction of this court.
This matter cannot move until you've proven jurisdiction, and you failed to do so. And if you cannot prove jurisdiction, then this matter needs to be dismissed with prejudice because this is a commercial matter. I'm a non-U.S. citizen American national by way of American Samoa. I'm beneficiary. I'm here sui juris in propria persona, and we cannot move any further on this matter until this is either dismissed with prejudice or you can prove jurisdiction.
So what would you like to do with your case? I assume, Mr. Parent, that you are not representing?
So the man cannot speak for me.
Okay, he's not speaking for you, but I am asking him a direct question, so I need you to let him answer.
Okay.
Yes, so the court did a
The public defender steps forward, clarifying that his office was assigned to the case, but Schuster wants no representation. The judge asks again, calmly, whether Schuster wishes to represent himself. Schuster refuses to give a direct answer, instead repeating his claim of sovereignty. The judge tries to simplify the matter, offering three options: accept counsel, hire private counsel, or go alone. Schuster remains locked in his argument, a man standing on principle, but drifting from procedure.
appoint us on this matter. But it sounds like he does not want my office to represent him, so I'm happy to withdraw.
You can dismiss yourself.
So would you like to represent yourself in the matter, Mr.
Please do
Schuster?
not tell me to shut up. You can dismiss yourself.
So he can't dismiss himself, only I can dismiss him. I'm asking you if you wish to have an attorney or if you wish to represent yourself.
This is a trust or Sisticate trust action. And so I'm here sui juris in propria persona. You know what that means. And so we can prove.
Don't know what it means because it's nonsense, but nonetheless.
Prove jurisdiction, or we can dismiss this matter with prejudice.
So I'm not going to do that today. Here are your choices. You can have Mr. Parent represent you. You can choose to obtain private counsel, or you can represent yourself. Let's start there. Which of those
Nobody's
three?
going to represent me. I can present myself, as I
Okay.
said.
So you wish to go pro se? I don't need you to read the script. I need you to tell me if you wish to go pro se.
A prosecutor joins the exchange, suggesting the hearing be delayed so Schuster can reconsider his position. But when the judge mentions scheduling a new date, Schuster interrupts again. He insists there's no need to continue because jurisdiction hasn't been proven. His voice sharpens. His frustration grows. The judge stays calm but firm, reminding him that proving jurisdiction is not her duty in this moment.
I told you, I'm here sui juris in propria persona.
Ms. Roberts, are you there?
Yes, Judge.
My inclination is to set this matter over and see if Mr. Schuster wants to give it another shot with his attorney or go pro se. It looks like this is the first pretrial. I suspect he's not prepared to set for trial today.
What is the first one? There's no plead.
Okay, I'm not speaking to you, so you're gonna have to wait. I'm speaking to Ms. Roberts.
I mean,
Judge, I would ask that we set this matter over 1 week.
Do you want to come back to court in 1 week and try again?
we can finish this matter now.
We
There's no
can't.
need to
We
move
can't.
this any further because
So here's
it's
the
not
thing.
proven jurisdiction.
Here's the thing. It's not my position today to have to prove jurisdiction to you.
It is. It is your position because
It's
it is
not.
on the courts.
And I'm also not going to argue with you.
There's no.
The courtroom atmosphere tightens. The judge sets a new hearing date for July 1st. Schuster objects, loudly, saying he's a man with things to do, accusing the court of operating under duress. The judge warns that if he fails to appear, a bench warrant will be issued. Schuster fires back, "Are you threatening me?" The exchange grows heated, voices overlapping. What began as a routine pretrial hearing now teeters on chaos.
So I'm going to have you come back to court in 1 week.
There's nothing you can prove that you have jurisdiction. This man does not speak for me.
So we're going to come back to court on July
That
1st.
doesn't work. That date doesn't work
Why doesn't it work for you?
because I'm a man. I have things to do. I've come here multiple times under duress with threats from your end, and I have no more time for this matter. And unless you can prove jurisdiction, there's no need for this matter to move any further.
But you're going to come back on July 1st at 9 a.m. If you
That
don't come back
does
on
not
July
work.
1st,
Are you
then
threatening me now?
I'm telling you, there's going to be a bench warrant issued if you don't
Are
show
you
up. So
threatening me now?
I'm giving you the choice of showing up
No,
or a
I'm
bench
giving
warrant
you the
issuing.
choice to finish this matter now or be responsible for your actions.
We'll set this for July 1st. I'm
Would you
going
like
to,
to be responsible for your actions and set this further? Because you
Schuster accuses the court of violating his rights, demanding the case be dismissed with prejudice. The judge gives one final instruction. He must return July 1st at 9 a.m. Schuster refuses to accept it, calling the process fraudulent. The judge attempts to end the hearing, but Schuster's anger spills over. "You can't tell me I'm done," he yells, insisting the judge has no power over him. The courtroom deputies exchange cautious glances, ready to step in if needed.
can do that, or you can dismiss this matter with prejudice.
I'm not going to do that today. So July 1st, 9 a.m. back in this courtroom.
Abigail, what's the reason for the threats, Abigail? You violated my rights enough.
We'll just hold Speedy for this
You
week, Ms.
violated my
Roberts.
rights enough. This matter needs to be dismissed with prejudice.
We'll see you back on July 1st.
Or else what? You're gonna threaten me?
or else the court will issue a bench
So
warrant.
you're threatening me now, Abigail?
I am telling you
No,
your
I'm telling you,
options.
this matter needs to be dismissed with prejudice. Because you cannot prove jurisdiction. This is a
Signature
separate
here.
trust action.
Signature here,
You're trying
please,
to
sir.
commit fraud.
Sir,
You're
Mr.
trying to
Schuster.
commit fraud. Miss, I'm
So-
speaking with Abigail.
You're done.
No,
you're
you
done.
can't tell me I'm done.
I
This
can.
is no, you don't have power to do that.
Your court case is
You
over.
don't have power to do that.
Sir, you're here.
As the judge orders the hearing concluded, Schuster threatens to charge anyone who touches him with assault. He gathers his belongings, declaring the matter dismissed. The judge's patience holds steady. She calmly records for the record that the defendant is leaving of his own accord, refusing his paperwork, and is expected back in court.
Hearing is over. If you don't take your paperwork and leave the courtroom, we'll have you remanded into custody.
You're threatening me now,
I'm
even more so
Giving you
than
a
you already
choice.
were. And if anybody tries to touch me, I'll charge them with assault and battery. So I will be gone because this matter is dismissed.
So for the record,
For the
the
record.
defendant's choosing to leave without his paperwork. He is expected to be back in court July 1st at 9 a.m.
This court's authority does not depend on your belief in it. Whether you recognize it or not, the law applies to everyone.